Okay, guys, we are starting Chapter 6, Part 1. Chapter 6, Administrative Agencies, is broken down into two separate parts, even done through the study guide. If you look through the study guide, Part 1 is more the history of it, and what administrative agencies do. And the second part is specific administrative agencies, such as the FDA, Consumer Product Safety Commission, and what they do specifically. Now, a few semesters back, some student was able to go and look over their exam, and they just noticed that there was a predominant portion of Chapter 6 on their exam, and each exam or each class sometimes will get more. Like you may have Management 209 on the Tuesday section. They may have a lot of Chapter 5, very little Chapter 6 and 7. The next one, Management 209 Thursday, they may have a little of 5, a lot of 6, very little 7. And then the 211 section, maybe have Chapter 5 and 6 a little bit, but then a lot of 7. It depends on how he wants to do it. Each person has their own different forms. We'll talk about that a little bit later on. I think with online videos, he probably won't have as multiple forms as he does. I think honestly, my opinion, he's going to make it a harder test. And then that way, if he needs to curve up, he can curve it up to his own level, rather than make it a little easier test, and because of him thinking it's cheating and not knowing how the proctoring exam is going to work yet, worried about cheating, he may be one of those people that just says, I'll make it harder and then we'll adjust, rather than make it easy and then, oh, well, then I'm not sure if they cheated or not, so he wants to probably make it hard. That's my opinion, and I may be completely off. Okay. When we talk about Chapter 6, everybody should have their purple packet here, all right? And for right now, the most important page you're going to have as we go through the historical part of it is this lime green sheet. And this lime green sheet you see, on the back side, it had all the different copyright stuff, and it had the 5 cases associated to products liability that we discussed at the end of the Chapter 5 videos. That 3-column chart with all the videos is probably pretty easy to answer any question. Like, I think it's number 18 in Chapter 5's back of the study guide. Any questions that you may have like that 3-column chart can answer. That's pretty big. And all of those have been on previous tests, so all of those would be Tier 2s, a few of them being Tier 1s as well, along with Paul's Graph versus Long Island Railroad, Hutchinson versus Proxmire with the Golden Fleece Award, and then Texaco versus Pennzoil, probably in the biggest case in Chapter 5 as well. But this up at the top has the durations of different types of intellectual property, along with the acts that go with certain types of intellectual property. Now on the back side here is probably the most important sheet. This is a sheet that I usually give blank to the class, and then we fill it out as we go through the notes. And as we go through, we fill it in, and I discuss how the questions are going to be phrased. Now that you have it already, I'm not going to have to waste, well, not waste, but use time. I can go straight to it because you can read it rather than writing it all down. We've also included other chapters that might be on this exam, but more than likely might be on Exam 3 and Exam 4, like the EEOC and stuff like that, that could fall under the jurisdiction of Chapter 6, but could also fall under Chapter 12, which would be now on your 4th exam. National Labor Relations Board being a big one that could be on your next exam with Chapter 8. So this chart is already filled out, and we're going to use it as a basis of going through Part 1 material of Chapter 6. Okay. Using the study guide as a basis of the notes. If you've never been to a tutoring review, we always use the study guide as a basis of going through the notes. So we're going to start on page 163 of the study guide for Chapter 6. So if you can get to 163, I'll talk a little bit more about a couple of things. On this lime green sheet, the first very top of it is some things at the end of Chapter 5, with all those 5 main acts that 5 main cases that I did on the flip side. And then the numbers 1 through, I think it's 7, yes, 7, is different things from Chapter 6, the early part of Chapter 6, along with the chart that we made. It's a 6-column chart. We'll go over that chart in about 5 minutes or so. Okay, on page 163 of your study guide, it talks about administrative agencies. And remember, administrative law is one of those sources of law. For your exam 1, you had in Chapter 1, you have what are the 5 sources of law. And I said, well, there's going to be one source of law, administrative law, It's much more important on a future test, and that was chapter 6. This is it. Administrative agencies are considered to be a fourth branch of government. Why is it a fourth branch? Because the three branches of government, Congress, the legislative branch, the president, the executive branch, and the court systems, the judicial branch, all are designed and a part of our Constitution directly, found within Article 1, Article 2, Article 3. There is nowhere where delegation of authority or anything about administrative agencies is located into the Constitution. So it's considered to be the fourth branch of government. It also is considered to be the fourth branch of government because it takes all of those other three branches, creating the law, legislative branch, enforcing the law, executive branch, and trying the cases, and does all of those on its own in its fourth branch of government within its direct administrative agency. Okay? So that is why we call it the fourth branch of government. The next thing you have is the history on page 164. It starts with the history. If you get your grain sheet, your line grain sheet, we'll be doing this six-column chart that's already filled in, so you don't have to do it. It's already filled in, but we are going to be discussing this six-column chart indirectly for the next 5 or 6 pages of your study guide. So have that along with the study guide as we go through the material. So if you look in terms of the creation, it talks about how an administrative agency is created through its enabling legislation from Congress. We'll talk a little bit more about that after we go through the history and all that stuff of the administrative agencies and the eras and the types of administrative agencies in just a few minutes. But if you look in the middle of page 164 of your study guide, it talks about the first federal administrative agency created in 1887, the ICC, the Interstate Commerce Commission. The Interstate Commerce Commission was created as the first federal administrative agency, once again, 1887. And he's not a stickler for dates, but this is one that he's actually had. You need to know dates because it also starts up what we're going to talk about, the historical era. It starts it up as well. The Interstate Commerce Commission was first designated to deal with railroads. It does a little bit more now, but railroads was its primary emphasis back then. It created the start of the federal administrative agency system, and by doing so, we have 3 eras. The first era is from 1887, the beginning of the ICC, to about 1930, 1932. This is called the historical era. There are going to be certain administrative agencies, and if you look, I think it's column 5 of that chart, it says era. When was this created? Okay, certain dates for the departments, but the eras for the administrative agencies. Okay, the first one is historical, 1887 till about 1932. After that is what I call the Depression and or New Deal era. New Deal is really more 33 through say 36, but anything in the 30s probably falls under the Great Depression, New Deal era. And then you have the socially conscious era, that is the 60s and the 70s. Now, without being specific and without saying always, the ones in the historical era are likely going to identify themselves as more industry-specific administrative agencies, and we'll get into that in a second. The ones that are more socially conscious, i.e. the 60s and the 70s, are much more considered to be economy-wide. That doesn't mean to say that you can't have in the historical era where economy-wide, you can't have any in the socially conscious era that are going to be more industry-specific, but the general rule is that the early predominant ones were much more industry-specific. The ones later on were much more economy-wide. The New Deal kind of goes half and half, so to speak. All right. The New Deal era, Franklin D. Roosevelt administration, stuff like that. We'll go over that a little bit later on. Now, when we talk about administrative agencies, each administrative agency is going to fall into basically 3 categories. The first ones are called Group 1, Group 2, and then the era. So if you want to make era Group 3, then we have 3 categories if you think about it. The first category we have is this administrative agency much more industry specific, or is it much more economy wide? Now, there's not going to be, an exact on every single one, but one's going to be pushing more towards the others. The first grouping is an administrative agency is going to either be industry specific or economy wide. That's what I call Group 1. Every administrative agency typically falls into that category. And then Group 2 is going to be, is it independent or dependent, also known as independent or executive? And that's my Group 2 category. And that's basically column 3 on your little sheet that you have. So if you look at the 6 columns, we have the administrative agency's full name. We have the acronym, in column 2. We have group 2, independent versus dependent. That should be a versus. Economy-wide or industry-specific is the 4th column. The era is the 5th column. And then basically the area that it deals with, okay? If you can memorize this chart, you can answer a lot of the questions that are fairly easy, but not for people that don't memorize the right material. Okay, so let's go ahead and get started with this. The first thing we need to talk about is group 1, industry-specific versus economy-wide. What does it mean about the difference between these two? Industry-specific means it only really tries to regulate one specific administrative agency. It doesn't focus on other industries. It focuses on just one industry. And if you think about the ICC passed in 1887, the first one, it dealt specifically and primarily with railroads. Therefore, at the time, it was much more industry specific. You could argue it's much more economy wide now, but at the beginning, it was industry specific, and that's what you need to know for this test. Okay? So 1887, the ICC, which would be the 4th one on your list, the ICC, acronym ICC, is, we'll talk about independent later on, but industry specific, historical, and dealt with the railroads. Now, when we talk about industry specific, we have a term which we call regulatory capture. And in regulatory capture it's where the administrative agency adopts a perspective of the business they are trying to regulate. Okay? It would be like, and then we'll do it at the state level, not federal. It would like be asking, TABC would be asking all the bar owners, what rules and regulations should we make for you to regulate your businesses? Well, most of bar owners would be like, oh, we want to be able to serve 24/7. We don't need a 21 and up drinking age. We can maybe make it 18 because we can hold our liquor. We don't want to have any liability if they drive after leaving our bar. If we didn't do anything wrong. Those are all things that the business owners would probably like to want. If the administrative agency, the TABC, or in federal equivalent, alcohol, tobacco, and firearms, was to mimic what the business owners wanted, then that thing has been termed regulatory capture. When the agency adopts the perspective of the business leaders, that is what we call regulatory capture. Now, how does he phrase this on the exam? Well, Form A may be an exam that says, which of the following likely administrative agencies is considered industry specific? And then you could have the administrative agencies with an acronym or the full name, so you have column 1 and column 2. And then you just need to know which ones are economy-wide industry specific. Or you could ask, which of the following do or do not likely use regulatory capture? If they do use regulatory capture, he's basically asking you another way and making you think about it a little bit. And if you don't know the term, you're going to be like, oh, I'm just guessing now. If he's asking you which of the following likely will use regulatory capture, he's just asking you which ones probably are industry specific. If he says which ones don't follow or don't probably have regulatory capture, he's probably asking you about which ones are economy-wide. So therefore, we could use that 4th column for industry specific, economy-wide to do it. So if he was just to give you a question on the exam that says which of the following are industry specific administrative agencies, then you could look at column 4 and attach itself to whatever administrative agencies fall into that category and be able to answer that question. Which of the following have regulatory capture? Same exact question, we just don't use the term industry specific. All right. The next thing we have is group 2, independent or dependent, also known as executive. If it is dependent, it is also known as executive. And those can be used interchangeably on the exam. In fact, there's one question, I don't know if he's fixed it or not, but it used to be for years where people got frustrated because answer B was dependent and like answer C or D, or I don't know, one of the other ones was executive. So both of those answers are correct, but he didn't have like an E, both of the above are correct, or A and B only, or A and B are correct. He didn't have that, so you had to choose between dependent and executive, and they were the same thing. And if you didn't bubble in the one that he picked, you maybe got the question wrong. I hope he fixed that question by now, but be ready for something like that. Dependent and executive is the same thing. Now, when we talk about independent and dependent, if you look on your line green sheet, that would be numbers 2 and 3 towards the very top. It talks about independent characteristics, and it talks about dependent, also known as executive. So if you want to write in parentheses executive, that would help as well. Now we need to go over the differences between this group 1 independent and group 1 dependent or executive type administrative agencies. Both of them are going to be under the ultimate jurisdiction of Congress because the budget is controlled by Congress. But the first question and the difference between them is, how were they created? An independent administrative agency is created by Congress, i.e. the legislative branch. The ones that are created by executive order fall under the jurisdiction of the executive branch. They are going to be called executive or dependent administrative agencies. So whether it's dependent or independent is how it's created. It's created by Congress, statutory law, i.e. legislative branch, or created by executive order under the president, i.e. dependent or executive. Regardless of independent or dependent, under this group 1 system, or group 2 system, the president appoints heads of those administrative agencies. Now, if it's independent, the heads are going to be like a 5-member panel. It's going to be maybe 3, 5, 7, probably an odd number panel. And the president is going to appoint all these heads of these administrative agencies. So if they appoint 5 members to the panel, then it's going to be 5 members appointed by the president. The president will have to show just cause for firing someone. There has to be cause shown to get rid of the head of an independent administrative agency. Whereas the president appoints a dependent administrative agency, president appoints the head, it's usually only one, probably only one for the most part, that's going to be the head of the administrative agency. The president can hire, i.e. appoint, or fire with or without cause for a dependent administrative agency. And if you think about it in Trump's administration, he has gone through a lot of his administrative agency leaders because they've either quit and or he's replaced them by firing. He doesn't have the ability to do as much on independent, where he has a lot more ability to do on dependent or executive. Okay? So in terms of that, president appoints. For either one, president must show cause for firing an independent. President does not have to show cause for firing in a dependent one. Now, another thing that I don't think is listed, but I want to talk about is an independent one has apolitical neutrality. Now, apolitical neutrality simply means if it is a 5-member panel or a 7-member panel, the panel must be compromised independently, meaning there can be roughly as much as evenly as possible between the political parties. So if we have a 5-member panel, and right now we're in a Republican presidency, it's probably going to be 3 Republican, 2 Democrat, because it's got to be even as close as possible. So a 5-member or 7-member panel would be 3-2 or 4-3, likely on the presidential side. When Obama was president, it was probably 3-2 or 4-3, but Democratic. Okay? Whereas dependent, you only have one sometimes as head. It's probably going to be that political party, that president, unless they like the person from previous. All right. So that's the main difference between independent and dependent on the exam. The apolitical neutrality, how they're created, how the president appoints, who can be fired, who cannot be fired with or without cause. But the biggest thing for help on the exam for you versus independent or dependent is an independent administrative agency is likely going to be called a board or commission. A board or commission. So if you look at those ones on our chart towards the bottom, the Federal Trade Commission, that deals with antitrust law, chapter 7, which we'll do later. FTC ends with a commission. That's going to be independent. Securities Exchange Commission, that's going to be chapters 9 and 10 on your next exam for the most part. Therefore, it's commission. There you go. Interstate Commerce Commission, going down a couple. That dealt with the railroads, first one, but commission. National Labor Relations Board, a board, chapter 8 on your next exam, ends in board, that's going to be independent. Okay, so you have all those things that fall under those jurisdictions when it's board or commission. If he gives you a question, I think there's one in the back of the study guide that simply says, which of the following is likely an independent administrative agency? And he gives you just acronyms or full names. Anything ending in a B or C is likely a board or commission, even if you don't know what it is, acronym-wise. Or if it gives you the full name, you know a commission or board is likely going to be independent. So if he follows that up and says, which of the following independent regulatory agencies was created during the historical era, you need to be looking for board or commission, whether it be full name or acronym, and then you need to be knowing which one is occurred in which era. Okay? So you have all different ways to go about, but that chart helps tremendously with all that stuff. Okay? So now we've talked about, other than the area of antitrust law, we've talked about basically all 5 of the first 5 columns. We've talked about the name of the administrative agency, the acronym associated to it. Group 2 is whether it's independent or dependent. Group 1 is economy-wide or industry-specific, what era is created in, and then the area that it deals with. You might have a question on the area that it deals with as well. Now, this chart and the 3 departments at the very bottom as well this chart is all going to be good for not only this exam, but it'll also apply for a couple of things on exam 3, a couple of questions on exam 4, with terms of chapters, and then obviously good for final exams as well. All right. So questions that you need to note is any 5 or any 6 of those areas under that chart, but you can kind of phrase it however you want. If he asks you which administrative agency is regulatory capture best associated to it, you need to be looking for the industry-specific ones. If you said switch to the following or independent, you need to look for boards or commissions. If it's dependent, i.e. executive or dependent, it is likely going to be an administration or department. Federal Drug Administration, FDA, or Department of Justice Antitrust Division, which is Chapter 7 material for antitrust law. Department of Agriculture is at the end of Chapter 6 with the USDA. These are all examples there as well. Now, the departments, I didn't put in an era because most of them occurred before all the administrative agencies started. So I just put the year that it was created. Remember, departments are generally under the jurisdiction of the executive branch. And even though some of them are treated as executive agencies, as independent administrative agencies are executive, they weren't created in 1887. They were created before that. Okay. So if we look at all that material, we went through page 164 and 165 on the study guide, along with the first half or first part of the first part of page 166 as well. Now, there is one term called independent executive. I don't see it happening as much on this exam compared to the exam 4 with the EPA, but there is one called independent executive, and that is where it is created usually by executive order by the president, but falls under the jurisdiction of Congress. So it has the independent characteristics of being under the jurisdiction of Congress, but it also was created by executive order, so it has a little bit of the executive. So it's independent executive. The ones that are there is NASA and EPA. You don't have NASA in class all year long, but you do have EPA for Chapter 14 on your 4th exam. So note that as well. Okay. The next thing we need to go over is basically how administrative agencies were created. That's on the bottom of page 166, top of page 167. When doing so, we need to talk about 2 case laws. Now, these case laws are not as important. They're definitely, if they're on there, they're tier 2s, not tier 1s like some other cases. But these cases are Schechter Poultry Corporation versus the United States and Yackets versus United States. And they happen about 8-9 years apart. Now, in dealing with this administrative agencies, remember I said there's no such thing in the Constitution about delegation of authority to administrative agencies by Congress, so the president cannot delegate this authority. So what happened is in 1935, or during that New Deal program initiatives, FDR created a bunch of different New Deal program work product type things during this New Deal era, closely associated to FDR's presidency. Okay? And many of the New Deal programs were found to be unconstitutional, one being the National Industrial Recovery Act. Now, that's on the bottom of page 166 of your study guide. It's also the precursor to the Fair Labor Standards Act, and that'll be on now, exam 4. It used to be on exam 3. It'll be now on exam 4 this semester. Okay? But it basically, by doing so, a lot of these things granted powers delegated from Congress to these administrative agencies to carry out all these things FDR wanted to do. Now, the Schechter Poultry Corporation versus U.S. case in 1935 said delegation of authority to these administrative agencies is considered to be unconstitutional. The courts deemed it unconstitutional, not allowed. Therefore, administrative agencies in 1935 were not allowed. They ruled the delegation of authority from the legislative branch to these administrative agencies was unconstitutional in nature. Roosevelt didn't like this. It ruined a lot of his programs and initiatives. He decided he wanted to reorganize the Supreme Court. He wanted to go from 9 Supreme Court justices to 15 Supreme Court justices. These conservative justices started voting in some of his New Deal programs and saying they were constitutional and stuff like that. And this is what we call a switch in time stage 9. That's number 1 on that little lime green sheet. The switch in time stage 9, not a stitch in time, which is procrastination, but a switch in time stage 9. FDR in kind of, because he was upset that the programs were getting unconstitutional and administrative agencies were not really being allowed, tried to pack the court from 9 to 15. Two of the justices, that's why I switch in time, two of the justices changed their mind about constitutionality to avoid becoming a larger Supreme Court. That's a switch in time, stage 9. Roosevelt's New Deal programs thus became a mainstay and began a program to help get out of the Great Depression before World War II happened. Now, Yackas basically said and kind of overruled Schechter and said, okay, administrative agencies, now their power is allowed to be delegated to administrative agencies, whereas Schechter Poultry Corporation said no, it couldn't. So we're that 9-10-year gap that we have from 35 to 44, it was unconstitutional for administrative agencies, but now it is, as long as they act in the public interest. Okay, as long as they're acting in the public interest, then they're good to go under Yackas versus United States. So just know the way the two court cases came about, and note that the in-between was a switch in time that saved 9 over the course of it. All right. The next thing we need to talk about is enabling legislation. And that is on the middle of page 167. It's also going to be talked about the bottom of page 167. And Ridley just talked about it as well on another portion of the study guide. So we're just going to get out of our way now. Now, whenever Congress makes an act, i.e. statutory law created by Congress, one of the paragraphs in that act is it's going to give an administrative agency likely the right to carry out the above act, to create rules and regulations to carry out the above act that created by Congress. So let me give you an example. On exam 4, you're going to have a lot on the Clean Air Act. So the Clean Air Act is created by Congress because they want to clean up the environment, at least from an air pollution standard. You're going to have some basic ideas, some broad strokes on what they want to accomplish, maybe even have some specifics that they want to accomplish as well. But one of the last things in that act, the Clean Air Act that's created, is that Congress is going to give the EPA the authority to do anything necessary and proper, so to speak, to carry out the above act created by Congress. And that is what is called its enabling legislation. If an administrative agency is given its enabling legislation, it stays within the boundaries of that enabling legislation, then they can create laws. So the EPA, maybe they create a law dealing with pesticides. We'll talk about pesticides in exam 4, especially, but a little bit earlier, a little on today. But pesticides, jurisdiction of pesticides, the FDA is in control of it. If they make a rule 16317 on pesticides use, then that act, Clean Air Act, dealing with all this stuff and pesticides, that rule created by the EPA 16317 or whatever number I gave, carries full force of law once enacted. And it's just as big as the Clean Air Act in terms of just as enforceable. Because most law that we have to deal with comes from administrative agencies' rules and regulations. Yes, the Clean Air Act is a big act, but, and all the different acts, Civil Rights Act of 64, but all the rules and regulations created by, say, the EEOC for Civil Rights Act and stuff like that, or the EPA in regards to the environment, are going to be most of the law that we have to deal with. And those administrative agencies, as long as they do everything improper, carry full force of law if they are given their enabling legislation. All right. It defines what we're going to use and which agency is going to be able to do it. All right. Now, the next two pages, 168, 169 of your study guide, maybe even a little over into 170, talks about formal versus informal rulemaking. Now, when we talk about formal versus informal rulemaking, the one thing that we need to note for test purposes, what's the difference? What is their common link? When do we use which one? And then maybe a couple other specifics, especially dealing with FDA. Okay? So the first one is whether we use informal or formal rulemaking. The first 3 steps to making a rule under administrative agencies is the same. The first step, agency thinks there's a need for a rule. Whether it be done under formal or informal, doesn't matter. The agency, whatever agency we're talking about, realizes there's a need for a rule. The second thing they do, the agency proposes or promulgates that rule. And if you use the word promulgates and you don't know what it means, it basically means proposes the rule. And it gets a little people drawn off when they haven't heard that term before. If the agency promulgates or promotes or creates that rule from the initial rule, the beginning, proposed rule, then that is step 2. Step 3, they put that proposed rule, promulgated rule, into the Federal Register. The Federal Register. Now, once those 3 things are done, identifying a need, promulgating, proposing a rule, putting in the Federal Register, then we diverge in either informal rulemaking or on the other side, formal rulemaking. Informal rulemaking is going to be much more interpretive, much more procedural based. Okay? Much more procedural based. The second thing, and then what we need to note is that after those first 3 steps, then under informal rulemaking, then after it's proposed and put in the Federal Register, it gives society 30 days for the public to give any written comments associated to their rule, whatever rule it is that was promulgated. After 30 days, that administrative agency can basically do whatever they want on a continuum. They can either adopt nothing from it, or they can completely ignore and start over that act, or that rule, or they can do anything in between by modifying it. So say the public sentiment is very against this rule. They may want to completely take on some of the expert opinions or the opinions given by the people in these written comments, and then maybe completely trash the initial rule and then start up again. Or they may just say, screw it, fuck it, and we're just going to go ahead and do the finalized rules exactly what we want to say. Or they could do some slight modifications in between. So they can either completely get rid of it, or they can completely ignore all the public or do something in between. There's a continuum, so to speak. All right? How they do that, whatever they do is fine. Once they have decided to finalize the rule, they'll put it back into the Federal Register. The old professor called it the Code of Federal Regulations for the finalized copy. SWIM says in the Study Guide Federal Register, we're going to go with SWIMs. So the Federal Register is where it's put in afterwards as well. And then no sooner than 30 days, sometimes it's even 180 days. Then once that rule will then go into effect after 30 to 180 days, depending, but a minimum of 30. And then it will become full force of law. Just like the Clean Air Act, that rule 16317 or whatever I gave is also a rule. It carries full force of law just like the Clean Air Act. Okay? Now, formal rulemaking is much more for substantive content or meat of the law. And in formal trial-like hearing, we have those first 3 steps: identify a need, promulgate, propose a rule, put it in the Federal Register. Then, under a formal trial-like hearing, we need to have basically a trial where evidence is presented, testimony is taken, exhibits are drawn, all that stuff. And it can take a long, long time, weeks, months, even years. Sometimes one, he says in the study guide, over 10 years. But to gain that evidence sometimes, or to gain that evidence needed for the actual trial itself, may take years to do. We'll talk about that when we get to FDA in a little while. Okay? So formal is going to be much more substantive, content or the meat of the law. Okay? Once you have had that trial-like hearing, the decision has been made, it's finalized, it goes into the Code of Federal Regulations, or SWIM says the Federal Register, I go with that for SWIM. Then after 30 days to 180 days, depending on how long it is, no sooner than 30 days, it carries full force of law as well. Now, on page 169, at the kind of mid-top, it talks about when are formal procedures and informal are going to be used, and when's a good example of when to use those and stuff like that. But also let's talk about FDA. FDA approval of drugs is going to use a formal trial-like, formal rulemaking, formal trial-like hearing. Here's the thing. Why does it take so long, which we'll talk about in part 2 of chapter 6, why does it take so long to create FDA approval of drug? Because maybe in order to grant approval, you need 8, 9, 10 years worth of data on potential side effects of this drug or effectiveness of this drug. Then we need to wait 8, 9, 10 years for that data. Then we need to go through the formal trial-like hearing process, and then we may have to do some changing after that to restructure the way they want the rule written. So that's why FDA approval of drugs takes a long time, over a decade, on average 12 years, and $250 million, $250 million on average for an FDA approval drug, because it's going to have to go through more of a formal trial-like hearing to be done. All right, on page 169, it gives a list of investigatory or enforcement powers for administrative agencies. This is something you just need to memorize under 169, number 3 at the bottom. They can require a business to report and self-report and monitor any issues. They can hold hearings. They can have subpoena power. Now, we talked about in exam 1, I said there was a thing called subpoena ducis tectum. And you may have it on this exam because of chapter 3, but more than likely it'll be on exam 2 and chapter 6. Or at the very bottom, page 169, it talks about a subpoena power. It's a legal instrument order to do something. A legal order for a person to do something. If the person is to appear in court and testify, that's subpoena ad testificatum. So simple. To testify ad testificatum. That's a fairly self-explanatory one if you get that. Subpoena ducis tectum is a subpoena to require someone to produce documents. So if you think about it in terms of testify, testificatum, or ducis tectum, ducis starts with a D, documents, then you note that for the test, and that's on the middle, bottom page of 169. And I said that might be on the exam, so be ready for it. It may require that a physical inspection of the business to occur with or without a warrant. You'll learn that in exam 4 now, dealing with chapter 12 on OSHA and warrants. There'll be a question on that, but understand that from chapter 6 as well, that you may or may not need a warrant in order to provide a physical inspection, depending on how the business is done. All right, on types of enforcement powers on the bottom of page 170, one of the tactics the administrative agency can do is it can threaten public exposure of data, it can cause a fine to exist, and it can remove products from the marketplace. That's later on, but it can remove products from the marketplace if it so chooses. All right, so that's enforcement power. Now on page 171 of your study guide, we have about 2 or 3 things that have been on test before and typically are usually asked almost every single semester. The first thing is, an administrative agency is considered to be the 4th branch of government because it in-house has all those other 3 branches of government. It makes the law, it enforces the law, it interprets the cases associated to it, all within the administrative agency itself. So it really doesn't have as much of the checks and balances system that the framers of the Constitution wanted, and therefore that's probably one of the reasons why delegation of authority to administrative agencies was deemed unconstitutional to begin. It violated the idea of separation of powers somewhat. Now, if you get cited for a rule, let's say OSHA, dealing with workplace safety, has a rule that says that you have to have no more than 1/3 of an inch of sawdust on the floor, or it's a violation. Say that's rule 72777 on OSHA. Now, OSHA would be the Occupational Safety and Health Administration. Administration would be dependent. It deals with workplace safety across all different industries, so that'd be economy-wide. It was created in the 1970s, so that's socially conscious. And if you look at your chart of those, that's right there an example. Now, that's maybe workplace safety will be on your next exam, or actually exam 4, I imagine. But nevertheless, there's just a way to go about it. But if you're given that question, you get cited for having 2/3 of an inch instead of 1/3 of an inch of sawdust on the floor, then you go in front of the administrative court to fight your battle on your citation. Well, here's the thing. The prosecutor, the one that's going to prosecute you during your trial with the administrative court, is going to be an employee of the administrative agency. That's self-explanatory. But the judge is also an employee of the agency, and that's at the kind of top of page 171 of your study guide under adjudicatory powers and procedures. Hearing is before an administrative law judge, ALJ, and I would note it's an acronym on the exam, who is an employee of the agency. So the agency acts as prosecutor and judge. Now, if they wanted to, they could really kind of keep everything in-house and really kind of screw over a lot of people. They're still somewhat independent in their decision-making, but they're not one that has a life term so long as they're confirmed by the Senate that we find with other constitutional courts as well. Okay? Once you do it, you have no jury. The judge is going to render the decision. So the judge, an employee of the organization, the administrative agency, is going to determine your fate when they prosecute you from an employee of that administrative agency as well. Okay? If you want to appeal the administrative law judge's decision, on the next page over, towards the bottom, middle bottom, you have judicial review of an agency action. And an agency action, in order to be reviewed, must have timeliness and standing. Now, what are these terms? The first one I'm going to do is standing. Standing means you must have a real adversarial relationship with the administrative agency. You can't just say, I don't like Rule 11613. It sucks. I'm going to sue, saying it's unconstitutional. What you have to do is find someone who has violated 1136, whatever number I gave, say it's 53, okay? You got to find someone that violated Rule 53 and then take on their case to say it's unconstitutional, this rule. And that's what like the ACL and different types of things like that do. They find a case associated to something they don't like and they want to try to fix. They want to get unconstitutional or constitutional or whatever they're trying to do. They'll take on a case pro bono to say, hey, here's a situation. We want this to be taken care of and abolished or redone, re-examined, whatever they want it to be done. If they think that the Rule 53 is way too harsh, they may want to say this is an unconstitutional rule. But they must find someone that violated Rule 53 and then take on their case when they have a citation. Then, after you find someone with standing, i.e. an adversarial relationship, it can't be just a hypothetical situation, it's got to be adversarial. Then, after the administrative law judges render the decision, there may be an in-house appeals process and you have to do all 9 or 10 in an exact order. Once you've done all 9 or 10, then you can appeal past the administrative law judge. And then you're going to go on to the circuit courts. I think you skipped the district courts. All right. That is on page 172 of the study guide. On page 173, 174, midway through 175, I haven't heard of anything being on the exam from those pages. Read if you want. I always ask people at the very beginning of each test round, was there anything I missed? Invariably, I'll skip a few pages every once in a while, and if I miss something, I always want to go over it, but I haven't heard about those being on the exam. Now, the last part of Part 1 material in Chapter 6 deals with 5 basic terms. There are 4 acts, and then a thing called sunset laws. This is the last thing from Part 1, then this video will be over. There are 4 acts: the Freedom of Information Act, Government Sunshine Act, Regulatory Flexibility Act, and on page 176 at the top, Small Business Regulatory Enforcement Fairness Act. And then there's a term called sunset laws, and then we're pretty much done with Part 1 of Chapter 6. Okay? Now, I haven't heard about Regulatory Flexibility Act or Small Business Regulatory Enforcement Fairness Act being on the exam. Not to say you don't need to look them over, but I haven't heard about those being on the exam. However, Freedom of Information Act, Government Sunshine Act, and what are sunset laws have been on the exam before. So you need to note those, okay? The Freedom of Information Act, and we have something in Texas similar, we call the Texas Open Records Act. So at the state level, that would be Texas Open Records Act, but the federal level, Freedom of Information Act. And what it says is federal agencies, because we're talking about federal, must make all information available that agencies collect available to any person. That person could be a business or could be an individual who requests that information. And once that request is given, then the burden of proof, if they want to give that information to everybody, has to be on the administrative agency itself. So say I'm somebody who wants to collect data or wants to collect information under the Freedom of Information Act. If there's a government federal agency that's collecting the data, I can request that data from that administrative agency from them, and they must give it to me, provided that it's not violating the Patriot Act or HIPAA laws or anything. But to decide whether or not it violates any of that stuff or it should not be given out to the public is going to be burdened on the administrative agency. And I would note that for a multiple choice answer. Maybe that's the difference between, say, C and D, where the burden of proof shifts from the administrative agency to the person. It's always on the administrative agency to decide whether or not that information should be given. And, HIPAA laws, excellent example, Patriot Act would be certain things we don't need to let people know. But if I was to say I was going to have a newborn and I wanted to know what car seats were best suited for my newborn infant, then I can collect consumer product safety information from, say, the Consumer Product Safety Commission, the CPSC, and they have all this data they've collected. I can request that information. They must give it to me unless they can show a burden under their burden that there's no reason they have to give it to me, and there's very few exceptions to that. Okay? The Government and Sunshine Act says that any administrative agency in which is appointed by 2 or more people, okay, must hold every meeting, every portion of every meeting in the open forum, subject to public observation. Meaning most administrative agencies that are independent, because remember, executive or dependent usually maybe only 1, whereas independent is usually an odd number, 3, 5, 7 members. If there's 2 or more that are appointed by that president, okay, then that must be subject to public observation. Now, this doesn't include the day-to-day, and if it deals with one of those things that falls like under HIPAA laws or something like that, that can be avoided as well as they meet the burden of proof. But the government must allow public observation of most of their in-house, not their in-house meetings about day-to-day operations, but much more their administrative meetings, okay? Day-to-day operations do not apply, all right? Regulatory Flexibility Act on the bottom, page 175, and Small Business on page 176, read on your own, haven't heard about that. But in the top middle of page 176, the last thing we need to go over for this video is sunset laws. Sunset laws is a basic way to decide whether or not an administrative agency's rules even applies to modern day standards anymore. And if it doesn't, we sunset, we get rid of it. Now, what's it say under D1 on page 176 of your study guide? It says state, not federal government. Sunset laws do not currently apply to the federal government. So if he says that the Consumer Product Safety Commission, which is a federal administrative agency, it's independent economy-wide during the socially conscious era, dealing with household, recreational, school use items. You'll learn that in part 2, okay? If they want to get rid of Rule 6372, they can't eliminate it under sunset laws because the federal government's administrative agencies can't do that. State, however, can. So if TABC wants to get rid of a rule because it no longer applies, that's fine. Alcohol, tobacco, and firearms, the sunset laws don't apply. Now, this 1 day a year thing that Texas has is called Texas Death Day. So if he gives you a question on the Texas Castle Law, that was Chapter 5, personal intentional torts, assault, battery, associated to protecting your property and others on your premises. Okay, but if we're talking about Death Day, we're talking about the day that an administrative agency at the state level at least will expire. And they can show justifiable reason for it to expire, we can let it expire on the death day, either extend it and keep it going or allow it to die. That is what we call sunset laws. So you need to know Government Sunshine, Freedom of Information Act, and sunset laws at the beginning of the very end of Chapter 6, Part 1 material. Then you have some ethical consideration. I don't think we need to worry about that very much. So we will start the next video on page 177, dealing with just 2 main acts, or I'm sorry, 2 main administrative agencies. That is the FDA, Federal Food and Drug Administration, and also the Consumer Product Safety Commission, SPCA. Okay, these 2 are going to be the rest of the 15 pages of Chapter 6. Now, I talked about briefly earlier how one student years ago, I mean, it's been quite a while, went and looked over their exam and just basically tallied up what percentage of the exam was each chapter. And Chapter 6, Part 1 had 10 questions on it. Chapter 6, Part 2, which is FDA and Consumer Product Safety, had 11 questions on it. So 10, 11, 21 questions, or 42% of their exam was just this chapter on 6. If you've thought about it and gone through this material, this is a much more memorization chapter if you memorize the right stuff. Now, for about 5 or 6 of the questions in the back of the study guide, that chart right here on that lime green sheet at the bottom will answer most of those questions right there. Then you have other things that need to be asked about. And I just remembered I missed one earlier on called the Administrative Procedures Act. The Administrative Procedures Act is on page 167 of your study guide. I forgot it. I just remembered as I was going through the little itty bitty things. The APA, or Administrative Procedures Act of 1947, basically was passed to create uniformity between all federal administrative agencies in how they are going to create rules and regulations. So if the Consumer Product Safety Commission and the National Labor Relations Board and the Federal Trade Commission and the Securities Exchange Commission, all of these different federal administrative agencies want to create different rules for whatever jurisdiction they're dealing with, they all must follow the same uniformity in creating those rules. the FTC, the SEC, the ICC, the Consumer Product Safety Commission. All of those have to use the same steps in order to make it. The same steps in order to make the laws. That uniformity across federal administrative agencies makes it a little bit more easy to understand the process. And that is on page 167. I remembered, I forgot about it and skipped over it just now. Okay, that is the end of chapter 6, part 1. You will have a video coming up on chapter 6, part 2, dealing with FDA and Consumer Product Safety Commission. Then you'll be done with the purple packet. And the next ones after these videos on chapter 6, we will do antitrust. I'll probably break it up into 3 different hour-long videos, or probably closer to 45 minutes each, because the normal breaks we have during class, you can decide your own break. Okay, so we are done with this one.